Professor M.R Sreenivasan is an academician, a practicing professional, or we can say our guru. Before introducing him, I will say he is always Guru Brahma, Guru Vishnu, Guru Deo Maheshwaraha, Guru Sakshat Parabrahma, Tasmai Shri Guruve Namaha. He is one of the most fantastic professors. He started his career as an advocate in Chennai bar about 50 years ago. He is completed his 35 years of teaching in Vaishnava College, Chennai. I am his one of the students who attended the classes in CS from 2006. He is a visiting faculty in CA, CS, CWA classes. He was also a visiting faculty in Bangalore in Christ College. He taught the law for the students about 50 more years. He wrote several books in that area: labor law, contract act, constitution. So many areas he has touched. His teachings we are mainly recording because he is young at 85, an enthusiastic person, always positive thinker. Anything to say, if you follow the video, if you watch the video, you will learn the law like anything. 100% I will assure you that these videos will be a lifetime remembering videos for everybody. Thank you.
Thank you very much, Ananda Krishnan. I do not know whether I deserve all your embellishments. Now, before explaining Contract Act, what is the importance of law? Because Contract Act belongs to commercial law. So what is law? Law is nothing but a rule of external action meant for human beings enforced by sovereign political authority. Then what is society? Society is nothing but the result of the reciprocal satisfaction of the individuals. You may have casteless society, but you cannot have classless society. That is why Plato said, in a society, you have got three segments. One is the philosopher-king class, is what is known as rulers. Then the soldier class, who protect our nation and country. And thirdly, the artisan class, the agriculturist, the blacksmith, the goldsmith, the carpenters. All these people, they belong to the artisan class. So you cannot have a classless society. You can have a casteless society. Well, what is the need for law? You find there is law in nature. Natural law, that's what we say. Panikkar, the famous historian, said, living in a surrounding so full of beautiful phenomena of nature, the ancient Indian gave spontaneous expressions to the feelings of his gratitude arising in his heart at the sight of the radiance of the morning star, at the delightful splendor of the early dawn, and at the majestic beauty of the rising sun. So there is uniformity in nature, unity in nature. There is theory of causation. The sun rises in the east and sets in the west. During rainy season, we get rain. During winter season, we are shivering with cold. Well, this is what is known as law of nature. Even among the animals in forests, there is what is known as jungle theory. Might is said to be the right. But even if you take chemistry, in chemistry also, if you fix hydrogen with nitrogen, you get water. And if you take physics, theory of gravity. So all these things, they are functioning according to the order in nature. But you cannot be definite about man. Why man? Man is a bundle of sensations. At what time he will lose his temper, at what time his behavior will become recalcitrant, nobody can assess and judge a man. He is a bundle of emotions. So if you want to control and regulate the behavior of man, necessarily we have to seek the help of law. What is law? Who is framing the law? It is the external rule of human action. It is framed by the sovereign. Though the concept of sovereign, as was understood previously, is entirely different from the concept of sovereign as it is understood today. If a determinate superior, not in the habit of obedience to a like superior, receives habitual obedience from the bulk of the given society, that particular superior is both political, independent and sovereign. This is what is known as Austinian theory of sovereignty. But that is no more in practice. Here we have democracy. Democracy is meant for society. It is for the people, by the people, of the people. So, in a democratic society, you find people are ruling. How do you find the people ruling? People are ruling through their representatives. Rajnarayan versus Indira Gandhi. There is a famous case. So, we are all governed by the democratic government. A democratic government is very, very important. So, society is nothing but the result of the reciprocal satisfaction of the individuals, as Plato has already defined it. Now, we are going to mention about the various laws and in what part of it does the Contract Act belong to. Now, you find law, as I said, consists of two important segments, that is, rights and duties. There can never be a law without rights and duties. You take any law, Sale of Goods Act, what are the rights of the seller? Then every right has got a corresponding duty. What are the duties of the buyer? There cannot be a right without duty. There cannot be a duty without right. That is the beauty of law. So now let us analyze to which part of legal aspects does this Contract Act belong. Now, law can be defined and classified as public law, private law, personal law. Public law, law that is going to regulate between individual and the state, or state versus central. Ours is a federal government. There is a central government, there are state governments. So the relationship between the central government and the state government. And again between the state governments inter se, between the state of Karnataka and the state of Andhra Pradesh, Maharashtra and Tamil Nadu, there may be disputes. So these are all aspects which are dealt with under public law. What is private law? Private law is a law that prevails between individuals, between one individual and another individual. And what is personal law? Personal law is nothing but the various observations according to the religion to which the individual belongs. For example, Hindus adopt a particular method of marriage. That is why we are governed by the Hindu Marriage Act. And if you take our Christian brothers, they are governed by the Christian tenets and they have got their way of marriage. And our brothers, namely our Muslims, they are governed by Mohammedan law. So, each segment in the society, now, Contract Act belongs to private law. Now, you see, in private law also, you have got various segments. You have got commercial law, non-commercial law, administrative law. You have got the other kinds of laws, which are applicable, Eastmentary Act, and you have got the various principles regarding the dealing of trade and all that. See, these are all completely applicable to private individuals, of which public law has nothing to do. So also personal law, adoption, marriage and divorce, these are all things that belong to particular religion to which, and it is applicable to the people who belong to that religion. So that is how you find. Now I have briefly explained these aspects. Now let us analyze. Contract Act belongs to private law. That is the thing which I want to emphasize. Now the other classification of law is what is known as substantive law and procedural law, or in other words it is known as adjectival law. What is substantive law? Substantive law deals with entire rights and duties substantially. Substantial law, in other words, it is what is known as substantive law. Adjectival law or procedural law. What is the procedure? Civil procedure, criminal procedure, evidence act, how to prove a particular thing, how to prove a promissory note, whether it is genuine or not, what are the presumptions. These are all things that are governed under the procedural law. Now, Contract Act belongs to substantive law. Now, coming to law, as I have earlier said, rights and duties are considered to be correlative terms in any enforcement of law. So, there are rights and duties. Now, what is right? Seems to be quite abstract, isn't it? A right is a capacity residing in one person to control the other with the assent and assistance of the state. Might is not said to be the right. You cannot exercise your right in the manner you like. See, right has got to be regulated. You cannot do, this is my right. You can exercise your right within the framework of law. So, right has got to be exercised. There is a capacity residing in one person to control the other with the assent and assistance of the state. Now, correspondingly, every right has got a corresponding duty. When you exercise your right, there must be somebody to recognize your right and oblige to you. That is what is known as duty. Duty is nothing but obligation. There cannot be a right without duty. There cannot be a duty without right. Ibi just ubi remedium, ubi just ibi remedium. Wherever there is a right, there is a remedy. Wherever there is a remedy, there is a right. This is the tenets of jurisprudence. Now let us now come to Contract Act. Contract Act deals with what kind of rights? Contract Act deals with right in personam. There are two types of rights there under general law. Right in rem, right which you have got against the whole society. You can exercise right in rem as against the whole society. Your possession, your belongings, your property, they are all mine. That is what you will say. That is your right as against the whole world. But whereas right in personam is a right which you can exercise only against a determined, specific, particular individual. You cannot exercise the right against the whole society. If somebody else plans to steal your watch, you can say, this is my watch. You have got a right against the whole society, X, Y, Z and all that. But whereas in a contract, we find that's what is known as personal right. Personal right means a right which an individual can exercise only against a particular person. For example, Mr. Shashank borrows 5,000 rupees from me and executes a promissory note. Whenever I ask him to return the money, he is dodging. Now what can I do? I can file a suit. I can issue a notice followed by a suit. That suit can be filed against whom? I cannot file a suit against Mr. Anand. I have to file a suit only against Shashank. So this is what is known as private right. That has got to be. So Contract Act belongs to, it actually speaks about private rights. And it does not deal with rights in rem. So this is what is known as right in personam. So you understand that. Now let us actually analyze the various other aspects of it. Now the entire Contract Act that is applicable in society is so essential that everyone, even a common man, must have basic idea about this concept contract. Now if you just look into the Contract Act of 1872, you can actually classify that under three parts. The first part deals with formation of contract. The second part deals with performance of the contract. The third part deals with discharge of the contract. And final part is and the final part speaks about remedies that are available for breach of contract. So this is how you should study. The method under which you have got to study Contract Act is how a contract is formed, how it is performed, how it is discharged, and if it has not been discharged properly, what are the remedies that are available to him. That is why what Anson says, what a man has been led to expect shall come to pass. What has been promised to him shall be performed. A has promised to supply 10 bales of cotton to B and has received 10,000 rupees as consideration. If A does not supply the bales of cotton, B has got to exercise his right and enforce A to supply the bales of cotton. And A having supplied the bales of cotton and B refuses to pay the money, then also A must be able to enforce his claim for money against B. What a man has been led to expect shall come to pass. What has been promised to him shall be performed. This could be done only by the enforcement of law. Now you just take the regular day-to-day transaction. In every regular day-to-day transaction, from cradle to the grave, from dawn to dusk, from womb to the tomb, we are entering into several transactions in which a contract is express or implied. So, there cannot be a transaction, particularly in commerce, without entering into a contract. It's all a question of fulfilling the honesty and the rectitude and character of a particular person speaks volume about the fulfillment of obligations. Having promised to supply certain goods, if another party is going to dodge and refuse to supply the goods, then in what way we can enforce him? We can compel him to supply the goods. It is only by the enforcement of Contract Act. So, the importance of Contract Act, you could have understood, is for the enforcement of rights and obligations. Now, having said about rights and obligations, for some time we will deal with the subject matter with which the Contract Act is going to speak about. Now, Contract Act is going to speak about movable property. What is movable property? Property that can be moved, that can be lifted, where you can possess it in its concrete form. What is immovable property? That which cannot be moved. For example, Transfer of Property Act deals with immovable property, house, vacant site, land and all that. These are the examples of immovable property. Now, coming to movable property, again the Contract Act makes two important classifications. One is movable property which comes under chose in possession. Another classification is chose in action. What is the difference between chose in possession and chose in action? Chose in possession is mere possession itself conveys ownership. That is why it has been rightly said, possession is 9 point in law. That means when you possess a particular commodity, you are the owner of it. That's why we say humorously, don't touch my pen, knife and wife. They belong to me. They are my property. But you can no more treat women as your property. She is a human being. Well, that is a different aspect and it goes at a tangent. Let us not waste our time on that. Now, so far as Contract Act is concerned, it deals with movable property. That is chose in possession. Mere possession itself conveys ownership. When you are having a 100 rupee note in your pocket, there is no need to say whether it belongs to you. The very fact that you are having a rupee note in your pocket, that signifies that you are the owner of that rupee. How you got it? Mere possession itself conveys ownership. You see the rupee note again. On demand, I promise to pay the bearer. a sum of rupees, you find the signature of the Governor, Reserve Bank of India. So, mere possession itself conveys ownership. What is chose in action, you have got to prove ownership though you are possessing that object. For example, you are having a promissory note. Now the promissory note is payable, the money is payable only to the promisee. How did you get it? You got it assigned. How did you get that assignment? You have got to prove it in a court of law. Mere possession itself will not convey title. Where you have got to pay, how you got the possession, you have got to explain. That is what is known as chose in action, encashment of check and all that. So, the Contract Act is going to deal with chose in possession and chose in action. Now, I am going to the next important broad topic, namely, contract deals with obligations and agreement. All contracts are agreements and obligations. But all agreements and obligations are not contract. In fact, the famous jurist Solomon has said, the law of contract is not the whole law of agreement, nor is it the whole law of obligations, but it deals with those agreements which creates obligations and those obligations which have got their source in agreement. What do you mean by this? All contracts are agreements and obligations. But all agreements and obligations are not contracts. Now we want to know with what type of obligation the Contract Act is going to speak, with what kind of agreement the Contract Act is going to deal with. Well, agreements are of three types. Agreement where rights are surrendered. Agreements where rights are assigned. Agreements where the rights are defined, protected, preserved, and they are enforced. So, where you have got agreement which defines, preserves, and protects, that is what is known as the agreement enforceable by Contract Act. So, agreement which creates, defines, protects rights and obligations, they are considered to be agreements about which Contract Act is going to deal with. Now, what are obligations? Obligation is a legal tie which imposes upon a determinate person or persons the act of doing or abstaining from doing a particular act. Abstaining means refraining. Acts, positive act and negative act, do's and don'ts. So, the Contract Act is going to speak about obligations which are considered to be a legal tie which imposes upon a determinate person the act of doing or refraining from doing a particular act. Now, you have got agreement with surrender rights. The Contract Act is not going to deal with that. Surrender deed. Agreements where rights are assigned. The law of contract is not going to deal with such type of agreements. With what type of agreement the Contract Act is going to deal with? The Contract Act is going to deal with such type of agreement which creates, defines, protects, preserves rights and obligations. Now coming to the other side, what kind of obligations are going to be dealt with under the Contract Act? There are social obligations. I may promise Shashank to come and dine with him in a hotel. Supposing I don't come, I do not fulfill my promise. Can he go to a court of law? No. This is a social obligations. Social obligations cannot be enforced. See, there is a famous case, Balfour versus Balfour, that speaks about the obligations prevailing between husband and wife. Balfour got employment in Ceylon. So when he was employed in Ceylon, before going to Ceylon, he promised his wife that so long as I am employed at Ceylon, I will give you by way of maintenance a sum of 30 pounds every week. But as usual, what happened? Promises made in storm are forgotten during calm. So he has forgotten it. He never fulfilled his promise. The wife went to a court of law and wanted to enforce it. The court said, no, you cannot. Because so long as you continue as husband and wife, is what is known as social obligations. There is no legal obligation. On the other hand, in another case, Williams versus Williams, both husband and wife got divorced. The wife said the husband has got to maintain her till she get remarried. But when this fellow never actually sent the maintenance money, which is known as alimony, the divorced wife filed a suit. And the court said here there is legal obligation because they are no longer husband and wife. So you find the law of contract is going to deal with legal obligation, not with social obligation. The law of contract is not going to deal with the obligations arising out of a compromise degree. A and B are fighting for passage of a narrow street or narrow lane in which both of them say they have got a right. Is what is known as easementary right. Everybody has got their own right to make use of the passage. And this fellow is tethering his cow and that fellow, the other fellow is tethering the dog. And they are fighting against each other like cow and dog. Now the court actually makes them to enter into a compromise. So you will tether the cow during night time and wash the place the moment it has become a day. And then you have got to tether the dog only in the night as a night watchman. So they enter into some sort of compromise. Well, the obligations that are arising out of a compromise, that cannot be taken cognizance of by the court. They have got to strictly abide by the obligations under which the compromise deed has been entered into. Well, the law of contract is not going to deal with social obligations arising out of a compromise. Obligations arising out of a tort. What is a tort? Tort is nothing but a civil wrong. I will give you a famous case, Pippin versus Shepherd. In that, a dentist entered into a contract with a dentist to remove the wrong tooth. Instead of removing the wrong tooth, the good tooth, the right tooth has been removed by the doctor. Then the question came up for consideration whether there is a breach of contract or causing injury to the patient. Now, the doctor was liable both under contract as well as under tort. So, tortious obligations arises out of a breach of a duty which a society owes, which a person owes to the society. That is what is known as tort, which could be remedied by liquidated damages, which is remedied by unliquidated damages, not by liquidated damages. Liquidated damages means that can be ascertained. The total amount of loss could be ascertained. Unliquidated damages is you cannot actually assess the quantum of damages. For example, if a doctor loses his finger, you see the amount of damages you have got to pay to the doctor is enormous. On the other hand, if an ordinary person loses, that is not of much help. So you see, every part of human body is very important to eke out his livelihood. Therefore, unliquidated damages. So the law of contract is not going to deal with obligations arising out of tort. So the law of contract is going to deal with what type of obligation? Obligations arising out of agreement. What agreement? Agreement which creates, defines, protects, preserves rights and obligations. So now you can answer the question. All contracts are rights and obligations. All rights and obligations are not contract. So this is the way in which one has got to answer such questions. Now coming to the other segment. We have already spoken about agreements and obligations. Now let us come to the next topic, namely sources of Contract Act, or in other words, sources of mercantile law. The sources of mercantile law are three in numbers. Number one, custom. What is custom? It is habituated conduct or activities of a human being that has been practiced and it has been observed for a long period. That becomes a custom. Your custom is always observed. The custom varies from people to people. The people in the south, they follow a different custom. People in the north, they follow another type of custom. So custom varies between person and person. Even here itself, the custom that is prevalent in one religion is not prevalent in the other. For example, the custom that is followed by our Muslim brothers completely varies from the custom that is followed by Hindu brothers. So you find custom varies from person to person. But custom has got to be respected. That is why, in a famous case, Collector of Madurai versus Muthuramangi Theivar, custom has got to be respected. Custom, clear proof of usage, will outweigh the written text of law. Now we leave the slippers outside the house when we enter into a house. That is Hindu custom. But whereas our Christian brothers, they walk into the dining room also with the slippers on. So it varies. I don't say which is best, which is not good and all that. But custom varies. The custom that is followed by one type of person is not followed by the other. It is what is known as regional custom and religious custom and all that. Next important thing is Lex Mercatoria, law that is applicable to merchants. That is why there is another important source. So from that only, the Contract Act has derived lot of information. Take for example the law that is prevalent among merchants has been adopted from law that belongs to the seaman. For example, the checks, the bill of exchange, the letter of credit, these are all things which we have derived from Lex Mercatoria, law that is prevalent among merchants. The hundis, for example, the Shahjogi hundi, the Jawabi hundi, the Namjogi hundis, these are all things, bearer check, order check, like that. Now the next important thing is common law. Common law that were enforced by kings and by exchequers, that is chancellors. That is why we have got, even in olden days, we used to record all the findings of the judges, namely the kings who presided over the courts. They used to be preserved under common law pleadings, as what is known as King's Bench, Queen's Bench, and Chancellor. So Chancellor is exchequer. So see, they were actually following the chancellors, namely they were following equity. That is one of the important sources of mercantile law. What is equity? Good conscience, justice, equity and good conscience. Justice, equity and good conscience, they are considered to be the three important aspects, magnum part of three aspects of equity. So magnum opus of three parts. There is justice, good conscience and equity. Now, what is justice? Justice must be tempered by law. See, justice, might is not considered to be the right. So, justice always must be mitigated by mercy. That is why, even in Shakespeare, you find the quality of mercy is not strained, it droppeth as a gentle rain from the heaven upon the places beneath. It blesseth him that gives and him that takes. So goes the passage. So, always justice means justice hurried is justice buried, justice delayed is justice denied. So, in jurisprudence, how justice has got to be dispensed with, the norms and standards have been prescribed there. Now, we are not going to be interested in that, but we say equity. He who seeks equity must do equity. He who wants justice must do justice. A person who is actually an offender cannot file a suit against another who is also equally an offender. When both the people are considered to have done a crime, see, one fellow cannot actually file a suit against the other. So both of them. He who comes to court must come with clean hands. His hands must be clean. Clean means not that he should wash his hand with Dettol soap. Clean means his hand must be perfect, in the sense he should not have committed any crime. So he who seeks equity cannot do equity. He who has infamy on his lips cannot touch the fountain of justice. A fellow who is an utter liar, he cannot try to seek justice from the court. So that is what is known as equity. these equity courts were superior to common law courts because the kings later on, they were not able to preside over the courts for a long time as a presiding officer because you see they got to study the custom. The custom that was prevalent in Yorkshire was different from Lancashire and so on and so forth. So they found it difficult. That is why king used to just preside over the courts on 3 days. That is Easter, Christmas and Pentecost. On these 3 occasions. But however, the chancellor, namely the exchequer, they were actually giving better justice than the common law court kings. They used to grant injunction. The injunction, what is injunction? It is nothing but an order pronounced by a civil court, compelling a person to do an act which he is compelled under law to do, curtailing a person or preventing a person from doing a particular act which he is prevented under law not to do. So these are all mandatory injunction, prohibitory injunctions, and so on and so forth. So you find these were granted by the equity courts. And specific performance, that also was granted by the equity courts. So you find these are the sources of Contract Act. So I will stop it there. We will go to next important topic consisting of the ingredients or requirements for a valid contract.